So you've spent a lot of time and money hiring people to help you develop and perfect your new invention. You're on track to launching that product and creating a successful business. Unfortunately, you've just discovered that you actually don't own the very invention you've spent so much time and money to create. Let me show you how you can ensure that your invention is protected and that you own all of the rights in the invention that you paid to create. I'm Elias Borges, and I'm a patent lawyer and registered patent agent with over 32 years of experience. I help people protect their inventions and get their products to market. If this is something that you're interested in, then you should consider subscribing. So who owns the intellectual property rights to an invention when one or more people work to develop and improve on a product? As far as patent law is concerned, anyone who makes an inventive contribution to an invention is an inventor and must be listed on the patent application as an inventor. Unless the patent is assigned, the people listed as the inventors jointly own the patent. However, when an inventor is an employee and the employee created the invention as part of their employment, then the invention is actually owned by the employer, and the employee is obligated to assign the patent to that invention to the employer. But there's a problem here. This principle only applies for employees. It doesn't apply to independent contractors. If you hire an independent contractor to help you develop and perfect your invention, then any inventions and any intellectual property created will belong to the independent contractor, not you. It doesn't matter how much you paid the contractor either. If they're not an employee, then they own the invention. So how do you ensure that you own the patent rights you paid to create? You have to get the independent contractor to sign an agreement which specifically states that any inventions created in the course of doing the contract work will be owned by you. The agreement has to further state that the contractor will assign their rights to you and execute any documents which may be necessary for you to secure your patent rights. This agreement must be signed by the contractor before they commence work on the project. This principle applies to other forms of intellectual property as well, not just inventions. That includes copyright. Any copyright in any work created by an employee is owned by the employer. But if the work is created by an independent contractor, then the contractor owns the copyright. More particularly, if you hire an independent contractor to write some software like a smartphone app, then the contractor owns the copyright in the code. In those cases, you have to ensure that the agreement you have with that contractor includes terms transferring ownership in any copyright to you. You also want to include a term waiving all moral rights in the work created by the contractor. Moral rights are a peculiar form of rights which apply to copyright and which are independent of a copyright assignment. If the person who created the work doesn't waive those moral rights, things can get complicated down the road if there is a dispute between you and the independent contractor. These copyright issues also apply to anyone who creates a creative artistic work on your behalf, including such things as artwork or even technical drawings. But what happens if there is more than one inventor working together to create the product? Well, each person who makes an inventive contribution to an invention is by legal definition an inventor and must be listed as an inventor. If there are three people who work together on an invention, but only one of those people made an inventive contribution, then only that person is an inventor. However, if all three of these people made inventive contributions, then all of them would be joint inventors. Now here's something to consider. As a joint inventor, and therefore joint owner of the invention, each inventor has an equal right to license the invention to a third party. This effectively means that none of the inventors have a right to grant an exclusive license without the consent and cooperation of the other inventors. Furthermore, it doesn't matter what the proportional importance of each inventor's inventive contribution is. They all equally and jointly own the inventor together. In these sorts of circumstances, it's usually a good idea to have each inventor assign their rights in the invention to a separate company or a separate corporate entity that will own the patent rights for all of the inventors. The shares of that company can be distributed to each of the inventors as the inventors see fit. This makes it possible to deal with the patented invention even if all of the inventors can't agree as to how to deal with the work. Finally, if you're getting another company to develop the invention for you, then you have to get assurances from the company that any independent contractors which they use to help develop the product are bound to assign the patent rights to you. So those are some of the most important issues concerning the ownership of intellectual property rights when there is more than one inventor or where there's some sort of independent contractor involved. If you have any questions or comments about this video, or if you have any suggestions for possible topics you'd like to watch me do a video on, then please leave a comment below. Thanks for watching this video, and if you like this video, please comment and give me a like. Thank you very much, and I'll see you next time.